Recording in progress.
Bring it up. People on Zoom, can you see and hear me okay? I
Yes.
can get a yes. All right, awesome. So thank you very much. All right, so let's dive into protecting yourself from lawsuits, right? Who wants to be in a lawsuit? Raise your hand. Come on. Raise your hand if you want to be in a real estate transaction that involves you now being in a chaotic situation because someone is upset, right? Well, no one wants to be in a lawsuit, you know? And quite frankly, in our industry, it happens very frequently, you know? So, how do we shield ourselves and protect ourselves from any potential litigation or lawsuits, right? It's utilizing common sense at the end of the day. So, let's go into what we're going to be discussing today. Number one, how agents get in trouble. Okay. Sometimes it's what comes out of your mouth will cause issues. Disclose what you know. If someone says something to you that you think is relevant, disclose it. Okay. Don't hide it. Don't shield it. Don't guess and think maybe I should, maybe I shouldn't. Okay. Any considerable material fact should be disclosed. Number three, don't be an expert. Okay. Our job is very simple. Find, market potential buyers, potential sellers. Okay. You're in the sales, you're not in the complexity of things that are legal, things that are in taxation. We're not experts on that. Our job is just selling real estate. Number four, document everything. Everything. And this is probably one of the biggest highlights of today's topic. Document from your texts to your emails to your voice messages, anything and everything. You want to document it, time stamped it, right? If something happened today, it happened at 9 o'clock in the morning. You want to document it. Why? Because if this ever comes back, you want to know when it happened, what time it happened, what's the reason behind it. Number five, own the contract. Okay. Understand the ins and outs of the contract is vital and super, super important. But understanding all of the other relevant documentations, right? From your advisories, your disclosures, understand the ins and outs of escrow, title, lending. Not that you have to be an expert on all that, but you at least have at least a base and a basics when it comes to, the process, right? All of these individuals and departments work together to get you to the finish line, to get your client and also the seller to the finish line. Make sense? Number five, never promise the outcome. Okay, never, never, never say, I promise it'll be taken care of. I promise that the seller will release the earnest deposit. I promise that the request of repairs will go through, right? When you promise and it doesn't happen, that's when people get upset. Know how to maneuver and navigate that. Also, number six is MLS marketing and utilizing AI. Who's using AI? Most of us are, right? But don't let AI be your broker, okay? Your team leader, your leadership. Use it in an efficient way, but also know the limitations of your position as well. As much as it's great to have AI as a resource, you cannot rely heavily on it as well. Double check, triple check with your department leadership as well, because that's important that they get involved as well. And number seven, if something already feels that it's going to escalate, it just gives you that little butterfly in your stomach. It's probably time to let people know. Okay. And the problem is that a lot of agents do not because they're in fear and they don't want that feeling, right? So they won't, and they'll wait until it's almost too late or too late already before they advise leadership something that's happening, right? The earlier, the faster and easier we can suppress that, right? It's no difference than a fire, right? When a fire starts, if you can at least suppress it early on before it becomes a wildfire, it's your best practice. Does that make sense? Okay. Here's a quote. Most lawsuits don't begin at the courthouse. They begin when something small that wasn't disclosed or documented or explained or gets escalated. Okay. And it's so true. We can avoid a lot of issues early on. And maybe you don't have the experience. Maybe you don't have the knowledge, right? Because maybe you just started. Maybe you haven't done that many deals. You're not up to date to a lot of things, and that's okay. The cool thing about what we have here, ladies and gentlemen, is that we have a great support team. We have departments that handle different stuff for your business. Remember, we say this quite often. You don't work for us, we work for you and your clients. You know how many times I've been in a three-way conversation with an agent's buyers or an agent's sellers or an agent's investors. Why is that important? Because I believe in rolling up my sleeves and getting to the bottom of it. It's when you avoid, and that's where we see a lot of escalation and frustration and people getting upset. It's when you avoid tough conversations. Instead of avoiding them, go charging forward, go head on, deal with it, the good, the bad, and the ugly. We all love giving good advice. Congratulations, Mr. and Mrs. Buyer. We closed the deal. Here's the keys to your beautiful home. Okay. Bad news, right? Oh, the buyers are deciding to back out of the deal. They're getting cold feet because the mortgage payment is a big shock. Or the ugly news, right? Mr. and Mrs. Seller, unfortunately, the buyers decided to back out. We're scheduled to close in a couple of days. Something happened. And there's a lot of moving parts, right? The seller might be already purchasing another property and is relying on the seller's proceeds, right? The seller's proceeds to be able to put a substantial down payment on their uplick. That's a disaster. That can happen, right? So there's a lot of things that can ultimately take us from a good position to a really bad position. Not sure why my clicker is not clicking. What gets agents into trouble? Okay. Here's just a couple of things that I've seen from my personal experience that I see agents get themselves into. Failure to disclose, misrepresentation, poor documentation, acting outside of your expertise, missing contractor deadlines, giving legal or tax or inspection advice, poor communications, agency problems, inaccurate MLS or advertisement, and trying to save the deal instead of protecting the clients. Your job is to demonstrate reasonable skills, care, and proper disclosure, document, and record. Okay. See, the problem is for a lot of consumers, and I mean buyers and sellers and investors, this is one of the biggest assets, real estate. We're not talking small change. We're talking hundreds, even millions of dollars. And we're in the essence, in the middle of all of this. You're licensed by the state of California and has granted you the opportunity to earn a commission. But it's how you utilize your understanding of the ins and outs. And the problem is you respect it and you have a very good career, I will be pushing 30 years in this industry. 30 years. And I remember being a young kid in real estate and thinking, wow, I got a long way to go. And now I reflect back as, gosh, where did my time go? Okay. But it's such a beautiful career to be in. And it has taken care of my family. And I know it can take care of your family as well. Now, it's not easy. What you put is what you get. Holding yourself with high standards, doing the right thing, never take shortcuts. This will give you a longevity in your profession. And the cool thing is there's a lot of great things happening, right? When I started my real estate career, we didn't have the technology that we have now. Look at where we're at now. We could be more efficient. All you need is a computer and a cell phone. That's all you need to do real estate. You can work anywhere and do real estate deals. That's the cool thing. So avoid any of these at all costs. Now let's talk about the standards, right? What are your standards? Is that for me? You're so amazing. I love her. She always takes care of me. But I came as a backup, so I had, thank you. I appreciate that. This is quicker. What are your standards? Okay. As hard as you work to get your real estate license, right? It's very easy to lose your real estate license. It only takes one bad mistake or error or judgment against you that will have a bad outcome. So your standards should be reasonable skills and care, proper disclosures and documentation. Document. Most of you know, many don't, but before I got into real estate, I was in law enforcement. And when I was going through the academy, um, one of the emphasis is good police reporting. And part of it was documentation. You know, what you have on your document will get you an opportunity to prosecute and put someone away, you know, because when this goes sideways, it's not just you that is looking at the contracts, it's not your buyers or sellers, but it's also attorneys. And their job is to dissect everything and find fault in the situation and then point fingers and what ultimately got us to this position. Was it the buyer? Was it the seller? Was it the agents? Remember, today's topic is avoiding lawsuits for us as real estate professionals. So maneuvering, navigating that approach is your responsibility. Because if you do something bad, okay, your license is in jeopardy. They may restrict it, they may suspend it, or they may revoke it. Now, today is not about putting fear, okay? That's not what today's class, but I'm putting fear in today's class because I want you to be educated as one of the top agents in our industry. And by doing so it's discipline. It's no difference than growing up, ladies and gentlemen. Growing up, you had parents that would discipline you, right? Because they wanted you to be a good sounding, more character person in life, to do the right thing, not to do the bad things or the wrong things, right? So that's kind of the elements of what we as real estate professionals need to understand. If you know something doesn't feel right, okay, it's probably something that you should avoid. Bring it to our attentions. We're here to help. Rule number one, if you know it, don't hide it. The California agents must disclose known material facts affecting value, desirability, and intent use in addition to visual inspection obligations. Okay. If the seller tells you the roof leak once, but we fixed it. Is that considered a material fact? Yeah. Okay. That's a good thing. Good job, Mr. and Mrs. Seller, for fixing the issue. Okay. The problem here is, in most agents' eyes, they believe that because it's fixed, it should not be disclosed. I have to disagree with that. Because the problem here is, if now it starts leaking, because we're not experts in roofs, we don't know who did the roof. What if they did a poor job on it? And then we get the heavy rains and it starts leaking, right? That can be a problem, right? What's going to happen? That buyer is going to complain to the buyer's agent. That agent is going to reach out to the listing agent, which in this case would be you. And if you didn't disclose, or your clients didn't disclose, yeah, we had it replaced, you know, well, was it done with a contractor, a licensed contractor, or a handyman? Was it done with permits? All of that is very relevant and very important. The addition might not have permits. There was mold, but we cleaned it. The neighbor and I have been fighting over property line. The plumbing backs up occasionally. The HOA is talking about increasing dues. There was an insurance claim. The previous buyer inspection found foundation issues. These are all relevant disclosures. If some of these come into your conversation with the seller, your job is, thank you, Mr. and Mrs. Seller. These are great things that we should disclose. Well, I don't want you to disclose any of this stuff because I want to sell the property. I don't want to pay any additional. So I'm requesting that you don't say any of these stuff. What is your responsibility then? Yes, I'm held to a higher standard. I have a license that grants me the opportunity to help, but unfortunately, I cannot put myself in that position. And if they still consist and push, then it's your responsibility to release them as clients. You fire them, because I'd rather not be in a lawsuit than now I have to write a check because the sellers put me in a compromised position, right? I don't want to go there. I want to protect myself. I want to have a longevity in my career. If I can do 30 or 40 or 50 years, do the right thing. I need this money. That's a big commission coming my end. I'm going to just take the chance and hope for the best. What you're doing is gambling. Okay. How many people have gambled and won huge amounts of money? You usually lose. You usually lose. You may be one of the lucky ones that will hit the jackpot, and you may be one of the lucky ones that you'll get away with it, but you're playing with fires, ladies and gentlemen, in my opinion. I'm about integrity. I can care less about the commission, but I'm in a different position, and I get it. Sometimes we have to do what we need to do, but it's not worth it. Because once it hits the fan, right? And I'm saying politely because we're recording this. Once it hits the fan, then it's game over. Now you have to defend your character, defend your position, and then you have to hire an attorney. And you may have to hire two attorneys. Well, Simon, what do you mean by two attorneys? And I'll explain. One for the situation where someone is damaged, and two, if they're going after your real estate license. And now the Department of Real Estate and the commissioner are reviewing this case because it got escalated to them. And now they want to see your practice. How are you running your business? Because you're an independent contractor. You're running your own business. Yes, you're under the umbrella of Keller Williams, but you're a business owner. You're your own CEO. Act like it. Act like you're running a very big organization. How will you protect yourself? do the right thing. Does that make sense? Or am I just putting smoke up there? All right. So the most dangerous sentence in real estate, I don't think that's a big deal. Hey, we're good. It's not a big deal. Should be all right. Never put yourself in that position. Because once you're in that hole, it's going to be hard trying to get out of the hole. And you can dig yourself deeper and deeper into that hole where now you're stuck. You're stuck. Don't decide materially for the clients, right? Let your clients be the judge. Now, your job is to guide and help them understand the consequences, but also look at it from liability. Mr. and Mrs. Seller, do you want to be in a lawsuit? No, of course not, right? So let's do the right thing. Let's put that as part of your seller disclosures. I'd rather disclose and know upfront that the buyer can do their due diligence, do whatever inspections they want to do with the peace of mind that we divulge and disclose that. Not that you have to do any repairs. See, the problem here is a lot of agents don't understand all of the moving parts. And once you understand all of the moving parts, it's easier to articulate the conversation with the consumer. Okay. Disclose, document, recommend investigations, and let the buyer, or in this case, the seller, make the decisions. Principal is the buyer or the seller. Never help a seller with words. A disclosure to minimize something serious, right? Now, you can guide them, but it needs to come from the seller's perspective, the buyer's perspective, right? And if the buyer or seller is asking you to do something that is illegal, unethical, or puts you in a compromised position, what should your position be?
You can't do that.
Yeah. Unfortunately, I just cannot do that, Mr. Seller, Mr. Buyer. Remember, as easy as they can fire you, guess what you can do? Yeah, you can do the same thing. You can fire your clients. Okay. You can fire your clients. Well, this is the only deal I have. I need the deal to go through. I get it. But what happens if you get in a situation because you were just looking at the compensation and the deal still falls apart and now you're in a lawsuit? That's bad. Double whammy. Just saying. I'm just saying. Rule number 2, don't be an expert. Well, Simon, I thought I was a real estate professional. Yes, you are. Okay. But I'm not talking about that. I'm talking about other things. Okay. You're the expert of real estate sales. You're not an expert of law. You're not an accountant. You're not a CPA. You're not a contractor. You're not an electrician. You're not a roofer. You're not a plumber. Okay. Don't act like you are. You're a real estate professional, not an attorney, CPA, inspector, engineer, or contractor. Don't say that's not mold. Don't say that crack is cosmetic. You're definitely building, you can definitely build an ADU. How do you know if you can build an ADU? Are you an architect? Are you an engineer? Are you a contractor? Do you know the city really well that you can say, yeah, I can build that? Or you can build that, right? Well, the square footage is correct. Okay. Well, how do you know the square footage is correct? Did you measure the house? Are you an appraiser? You definitely can get the permits. How do you know you can definitely get permits? Right? What if you can't because the previous seller did it without permits? And now the city has to get involved and they may ask you to knock some walls down to expose the infrastructure, right? It's going to cost a lot of money. You don't need an attorney. Okay. No, it's on the reverse. Everything should be, yeah, I highly recommend that you speak with an attorney. Don't be in fear of telling your clients, speak and get guidance from an attorney. You know how many times I say it on conversations with the agent's clients? I would encourage you to speak with an attorney, even when they're pissed off. And it says, well, if I cannot get this property, I'm going to get my attorney involved. Whoa, whoa, whoa. A lot of agents get in fear mode. Instead, I would encourage you to do so. Please. I push it because sometimes it's a bluff, my opinion. Okay. What you should be saying is that's outside of my area of expertise. I recommend you investigate it with the appropriate qualified professional. Take a photo. If you want a copy of this slide, send me an email. I have no problem sharing all of the stuff. That's what I'm here for. Y'all with me?
Yeah.
Okay. Are you being educated today? Did this go backwards? Yeah. Okay, let's go to the next one. Your value as an agent. Is it okay to not know everything about real estate? Absolutely. I'll be the first. 30 years. Steve, how many years in real estate?
42.
42.
I'm still learning.
Okay, that's what I was going to say. Do you know everything about real estate? Yeah. You see,
I know.
this is a seasoned, experienced individual with 42 years of experience, and he can, with confidence, says, "I'm still learning." That should be your position as well. Oh, I got 3 years. I've closed 100 deals. I think I'm an expert and know everything. You may know everything, and that's great. But be very careful because when you come from that approach and something happens, they're going to point at you and says, well, he said he was the expert on that. Okay. Be mindful. Knowing when an answer needs to come from someone else, right? It's okay. And the anxiety that I see with a lot of newer agents is they feel that they have to know everything because they don't want to look that they don't know, right? And that should be the total opposite. You know what? That's a great question. I don't have the answer, but let me do a little bit of research. Let me get in contact. If it's an escrow question, who should you be referring it? Yeah, that's a great question. Maybe we need to speak with the escrow officer that's handling our transaction. If it's a title situation, great. That's a great question. Let's get title involved and let's get it from them. They're the ones that create the title reports. Why should I know everything about it, right? You should know some, but let's get the experts that know better. A general home inspection, right? Yeah, there's a lot of information. Great. I'm not an expert in this field. Let's get the inspector that did the work and get it from the expert that actually went and did the physical inspection for your property. Recommending the right experts at the right time is a professional competence. That means it's a good thing. Okay. And here's a lot of situations that I see is that now the agent is backpedaling because they said something that they shouldn't have said. It's okay, ladies and gentlemen, to say, I don't know. Don't wing it. You all with me on that?
Yeah.
Okay. Because I don't want you to feel that I'm not going to get the listing, I'm not going to get the buyer, and you try to wing it. I'd rather work with someone with honest integrity and someone that's a hard worker and that's devoted and dedicated. That's not going to get me in a sticky situation, but I want honesty. I don't want you to sugarcoat it and think that you know and you really don't. And I'll be the first. I'll be the first in many conversations. I'm not an expert. I don't know. That's a great question. Let me follow up with you on it. And then bring the people that can help you with that. That puts the relief off you. Make sense? Let me just move this a little bit. Rule number 3, document, document, document. Remember when you got into real estate and when you were going to real estate school, they would always say, they would say location, 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 right? And then now that you're in real estate is, disclosures, disclosures, disclosures. But one of the missing links to that is now you're a real estate professional, right? And everything that we do has to be documented. This is why we have so many pages on the purchase agreement, advisory disclosures. By the time a transaction gets to the finish line, you're probably looking around 3 to almost 400 pages of documents that you're delivering to your client. Okay. And that's just not the real estate stuff, the loan docs, the escrow, the title, the inspections, the termites, plus all of your shenanigans of paperwork, right? Like this. Here, Mr. or Mrs. Buyer, congratulations. It's a lot of paperwork. It's no difference than when I see attorneys when we're in a mediation, arbitration, or a lawsuit, and they have their 3-ring binders and they got stacks of paperwork and they have exhibits and they're going through all of their exhibits. It's like, holy moly. And remember, all of these are relevant in our transactions, but all of this gets dissected. If your name is on it, you're part of that. You're named in it. When they're researching, they're going to say, Simon with Keller Williams license number. Boom. Let's bring him in. He was involved in this real estate transaction. If the transaction goes bad 6 months from now, I don't want your defense to be by memory. Okay. I can't even remember what I did last week sometimes, let alone 6 months from now or a year from now, ladies and gentlemen. Think about that for a minute, right? You close, say, 10 deals. Are you going to remember everything that transpired on all of your 10 transactions? Not all of the details. But what you do have is your documentation. That'll bring something that you forgot. That's right. I remember having that BRBC signed, and there was specific language that the buyer wanted, right? That's your defense right there. Your text messages, right? Save all your text message, put them into a file, and keep it into a real estate transaction. Because you never know. Well, Simon, I didn't think texts and emails were relevant. Everything is relevant. That's your defense. If someone is going after you, you want to use all of your arsenal, right, to defend yourself. That's voice messages, text messages, emails, any videos too. Okay, that might be videos that you did. Put it all together and have your own personal. Keller Williams has their own files, and we hold on to your file for 7 years, even though we don't have to hold them by the Department of Real Estate standard of 3 years. We hold them for 7 years. Your TC should be able to hold them for 7 years. But also create your own files as well, because maybe they don't have all of the dialogues and communications. They just have documentations on car forms, but you have all of the meat and potato of a situation that will protect you or your client. You look like a superhero, in my opinion. Client instructions, recommendations made, inspections issued, contingency decisions, seller disclosures, material facts, repaired negotiations. All of these are back and forth sometimes that are not documented. Remember, you got to tell the story from beginning to end, right? Because that's what an attorney does. They try to dissect and prepare their case because their goal is to show that you or your clients did something wrong. Does that make sense? Important decision, document decision. Okay. That's going to be your best defense, in my opinion. All right, so let's go through a scenario here, an Oreo contingency removal. Your buyer tells you on the phone, I'm okay removing contingencies. What do you do next? Confirm the instructions appropriately in a written documentation. Use contractual documentations, right? So if a buyer is okay to release and remove a contingency, what form should you be using? Okay. You should be using the contingency removal, the CR form. Okay, that's your document to release a or some or all your contingencies, right? Um, because what comes out of your mouth will not hold in court, but what you document will definitely hold in court. Okay, and that goes even to a mediation or an arbitration, right? I see mediators and how they work. They're referees, basically. Okay. They're not here to side with either party. You can be in the wrong. You can be on the wrong. They can care less. The outcome is a resolution. What can we get out of this to get it to the end, right? Whatever that decision is. Because it's not always black and white, ladies and gentlemen, even though we talk about everything is black and white. Documents are, right? And you still want to follow that position, having the right documentation, having your clients acknowledge, understand, and that they have read it. And this is why you have them sign the agreements, right? But also understand that it's not always black and white. And that's the beautiful thing. There's a little bit of a bend on contracts. And I'll explain it a little bit more, okay? Because that's how I was trained is documentation, black and white. It's on black and white. And yes, it is. If you understand the ins and outs and you really dissect all of the documentations, right? Not just the purchase agreement, that's also the listing agreement. That's also your advisories, your disclosures, right? Yes, because now it puts you in a position of knowledge and no one can penetrate that because you understand the contract so well that now you can illustrate it, articulate it, explain it, right? And someone will try to push, and they may think because of a situation that went their ways. No, you always go back to the contracts and what the contract states. Now, the other element of what I call the not so black and white is the outcome, right? The contract is an instruction for both the buyer and the seller. These are your instructions, your rules, your follow instructions, right? And when something doesn't align or doesn't go the way it's supposed to be, there's what we call a dispute. And when there's a dispute, okay, then we need to figure out what the solution is. Do we step in forward? Do we stay neutral? Or do we take 2 steps back? That's where you need to know and understand, okay, that's my flag there that I now need to bring additional support to help me. I'm going to stay neutral because I'm here for the best of my client's interests, but I don't want to be in the chaos of this. Maybe I need to speak with someone that knows better. That's when you bring leadership in. That's where you take a step back and let the support team help you with this, give you guidance. And that's where I even will say, you know what? I think we need to get the attorneys involved. And I have no problem. Even though I know a lot, I still rely on our legal team. That's the cool thing is you have your backup to the backup. Let's get legal involved and let's get their perspective. Okay. Because then it puts me in a different position. Because then they're going to say, well, my broker told me. I don't want to be in that position because then it's my license as well. And I'm not even involved in your real estate transaction. So I have to be mindful and cautious of what I say too, as well, because I'm not an attorney, but I do know a lot. My job is to help and support you, but also protect you as well. I'm that extra layer of protection as well. Because if you go down, I go down as well. And I will never do that. Okay. Because remember, I've been in this industry for a very long time. I'm not going to jeopardize my license either. If you do something wrong, you're on your own. Okay. I'm not going to support you when you're doing something that you shouldn't be doing, because then it impacts my license. I have a very clean license. Don't mess it up. And again, today's class is not to put fear, but a better understanding. Okay. Just a better understanding. Your buyer tells you on the phone, I'm okay to remove contingencies, right? So we want to make sure that you understand there's proper documentation to do so. And you can tell them, hey, thank you so much. Not a problem. Can you send me an email on that? Okay. I just want to make sure that I have it because you might be doing a lot of other stuff and you may forget too. And that deadline could be the vital position that they may be in a position where they get canceled. Okay, so you want to document it so that way you can now have something that you can reference. Oh, yes, I forgot that I have to, get that contingency removal because, we're running out of time, right? So it's always good to document it. The goal isn't 100 emails about everything. The goal is important decisions and documentation decision. Okay, and throughout the presentation, it's all about decision making and understanding where you stand. Does that all make sense? Okay. Rule number 4, the contract is your road map. Who is responsible for tracking the contract? The agent?
The PC.
Okay. Yeah. So it's a responsibility of yourself because you're drafting these contracts, right? You're putting these paper documents in front of your clients, right? Not escrow, TC, lender, or the other side, right? So know your dates, own the timelines, right? So kind of a guide here that'll give you kind of an understanding, right? Your deposit, your disclosures, your investigations, your loans, your appraisals, your requests of repairs. And guess what? This is where most of the deals fall apart.
Yeah.
They're in this section right here. Okay. Request of repairs, when buyers are doing their due diligence, asking for everything. They want a brand new house. They want a new construction, right? And the seller says, go pound sand. I'm not going to do that. I'm not living in the property. I didn't even have a brand new house, and you want me to give you a brand new house. So remember, all properties are sold in as is conditions, right? But what should be reasonable, right? If it makes sense, because most of the deals fall apart during the request of repair period. And then, ultimately the next step would be contingency removals. What you're telling the seller is that I'm still moving forward. I still want this property. And because of that, I'm still pushing to get the final funding and get the deal closed. Make sense? Okay. Any notice, basically any notice to performs. Remember, if someone sends you a notice to perform, they're basically saying, hey, I'm warning you, if you cannot get your clients to perform, we're canceling on you. Once you understand all of the elements of this, it's just easier for you to get to the finish line. Okay. And the last part is the closing, right? That's when you can do the happy dance. Don't do the happy dance until you get confirmation of recording. Okay. Just because the money goes into escrow and it gets fun, anything can happen. So don't count your ducks yet until they say, congratulations, we confirm confirmation. Okay, that means that they officially recorded at the county recorders. Now you can do the happy dance. Okay, if you know you're getting a commission. All right, so let's talk about a scenario contingency and pressure, right? Because this is where I see most agents have anxiety, in my opinion. I see a lot of issues when it comes to this contingency, right? So situation, inspection contingency deadline is tomorrow. Buyer still has concerns about the roof, sewer, and the foundation. Listing agent demands contingency removal today or will issue a notice to perform. Okay. So that happens quite often, right? You got some very experienced agent, especially. Remember, most listings are usually experienced agents, meaning they are heavy listing machines. Okay, so they know their stuff. They know contingencies, periods, their TCs should be on top of it, right? Because for someone like Steve here, he's going to be all over that, right? Because he doesn't want to delay this any more than he should or his client should, right? Because if they're dragging their feet, they're going to cancel. You got to be efficient. The goal is if you set a date to close, right? And it typically is 30 days from acceptance, you want to close at or just before that date, right? And this is why you're pushing everyone to get to the finish line, making sure that everyone is aligned, everyone is doing what they need to do. Where we see a lot of things go sideways is because you're not in constant communications. You just kind of open escrow, clean your hands, and then let everyone else do their job. And you kind of just drop the ball on there. And it happens. Well, get ready to write a check. Okay. Because if you are not on top of your transaction, shame on you. Shame on you. Okay. So your approach should be explain the situation, the risk and contractual options, recommend appropriate investigations, right? You're not telling them do X, Y, and Z. Okay, that's not your job, but say, here are the options that you have, Mr. and Mrs. Buyer. Okay, you can do one or you can do all. It's up to you. Well, Simon, what do you recommend? Okay, well, I recommend that you at least get the minimum a general inspection. Okay. Depending on the property itself, right? The age of the property will determine what else we should be looking at too, as well, right? Sewer lines are some of the biggest issues right now that we're seeing. Getting a sewer inspection, right? What does that entail, right? Well, plumber goes and gets a camera and goes and looks at the sewer line. Wow, that's nasty. Yeah, it's nasty, but at least you know what you're getting or your clients are getting into, right? A roof inspection too, right? All of these are part of the initial process that the buyer can do as part of their due diligence. Okay. So what if they tell you, well, I don't need to do any of these inspections. Okay. I'm okay buying the property the way it is. What should be your next step? Say again?
Is there what is it? Well, I don't know, or some type of release. Is saying that because I don't know. Is it something that says they don't have to do an inspection? Some kind of form that says that, or and they already know as is, but.
Yeah.
It's a waive that they waive the inspection. That's waived. It's a check box.
Yeah. Yeah. Steve?
If the buyer ever says they don't want to have an inspection, that is absolutely their choice. Okay. It's always important to advise that it is against your advice. Okay, highly advise it. However, okay, it is still their choice if they choose to move forward. We do have a form, okay, of CAR, to get the actual name of the importance of getting a home inspection. Okay, and so you have them sign that, and you have them, and there's a form of against broker advice of that they are moving forward, not following the advice of you as the agent. Okay, and that's perfectly fine. There are times in which, based on context of the situation. I think almost on everything that Simon is covering here, everything falls under under the umbrella of how things are handled based on the context where things are in the transaction and the marketplace. Okay, I'll give you an example. I'm a listing agent on a townhouse that we're in escrow on. And the buyer's agent is a relatively newer agent, and she's being very, very cautious, okay? And she's tried to do really well for her buyers, but the newness of her is really showing through. And so one of the things they requested yesterday was a 3 business day extension to the investigation contingency. Of which then I discussed with my seller, and I said, well, let's give them 3 calendar days. Of which then my initial seller, one of my sellers said, I don't want to give an extension all past Sunday. Okay. And so the context of which my discussion with them went, okay, Mr. and Mrs. Seller, right now, we've been on the market for over 60 days. This is our only offer we have. We have nobody in the wings, okay? If these buyers were to back out because of not liking your response, they have that contractual right to back out. Well, they do? I said, absolutely. They're still within their investigation contingency. So within the context of, we don't have any potential backups. The context is, I advise you to give them their extension because their areas of concern within their investigation are more annoyances as opposed to major big issues. We should be able to get them resolved. That's my perspective as their listing agent within the context of, we should be able to get it. Let's not argue on the timeline so that we can then focus on the issues of their concerns within the investigation. So whenever you understand context, you then are able to properly advise.
Yeah. Thank you. You are the advisor, not the decision maker. Okay, so you're not there to tell them, yeah, let's do this. You tell me what you want to do, Mr. and Mrs. Buyer, right? You're just advising them. You're not telling them, let's do this. They have to tell you. And that's the problem where we see a lot of agents get in the chaos of controlling all of that. And that's where you may get yourself in a sticky situation. All right, rule number 5, never promise the outcome. Okay, avoid these absolutely, right? The seller will fix it. Okay, you'll get the house. I promise. You'll get the house. Been talking to the agent. You'll get the house. Your deposit is protected. The appraisal will come in. Okay. Yeah, I did my own comps. I think the appraisal will come in. It's easy to have that conversation, but the problem here where I see is if it doesn't happen, then they get very sensitive. This will close. I promise. I promise it will close. The seller has to give you the deposit back. Yeah, you didn't release your contingencies. The seller has to give your money back. The better language is, based on the contract, this is what it's telling us. Subject to the appraisal, subject to the applicable contingency, right, is the best language when it comes to you'll get the house. Your deposit is protected. The best is, let's review the agreement. Okay, let's go through it step by step and understand. I cannot guarantee the outcome, Mr. and Mrs. Buyer. I don't have that crystal ball that's going to tell me that this is going to happen. And it's okay. Let's confirm that with escrow, title, lender, and legal counsel, right? Because once you put yourself in a position that the seller will return the deposit? How do you know that the seller is unhappy or pissed off and they don't want to release the cancellation and they feel entitled to your client's deposit? And you know how often that happens? Because they see money there that says, well, let's tap into the buyer's deposit. They breached the contract. So there's a lot of moving parts to that. And I want you to understand it's not our job and our obligation to say that the seller or the buyer will do. Okay. No. Okay. That's not the approach that you need to be. The approach should be is, look, maybe at this point in time, we need to get the broker involved, or maybe we need to speak with an attorney and guide you on what the next steps are. And it's so easy, and I get it, folks. I get it. And remember what I said earlier, right? A lot of times we just go through it with no issues, right? We just kind of slide right there, right? It's like, I don't know what it's called, but two individuals are holding a rope and there's music and then you're dancing to it, but you're bending back, right? And you're trying not to touch and then it gets drop, and you're what's it called? Limbo, thank you. Right. And your job is, okay, I can still come down, right? But the minute that you touch that, you're done, right? Well, you feel that you can do it, right? But there's a certain limitation that it's going to be very, very low, right? And I've seen people literally almost to the floor. It's like, how do they do that? But you're going right on the surface of things that may still go sideways, right? I rather play it safe. No, thank you. Let me just do the right thing. I'll just go and provide you what the next steps would be. Explain the process. Don't guarantee the results. Okay, that's my best advice. Rule number 6. MLS marketing and AI, artificial intelligence, can create liability, right? So this is again straight from the Department of Real Estate. The DRE alerted. Back in March of this year, AI does not relieve an agent from responsibility. So you cannot blame AI, right, for inaccurate advertising or disclosures. Licensees must independently verify factual claims produced by AI, right? It's a great resource, don't get me wrong. Okay. But ChatGPT isn't going to your DR hearing. You cannot say, hey, I'm going to bring ChatGPT. Talk to ChatGPT, right? No, doesn't work that way, ladies and gentlemen. Unverifiable MLS claims to avoid permitted additions, ADU potential, buildable, new roof, fully remodel, approximately 2,000 square feet without verifying sources, right? School information, zoning, use claims. Now, a lot of the stuff is public information and you can rely on public information, right? But if you don't know, you don't know. Let's leave it alone. Okay. Where is the sources coming from? Okay. That's the most important thing, because if something goes sideways, well, it alleviates you being the target, and now you can bounce it off on the source that it came from. If an appraisal was done on the property, right? And the appraisal said, that your property is 2,500, but on Realist or public information says it's 2,000 square feet, but the seller is telling you, well, the appraisal says 25. I want to go with that. Where should your sources come from now? What are you going to say? Okay. Can you say the appraiser? The sources came from the appraisals report or from the seller? Well, I believe you can say from both, right? Because the seller is telling you that the information is from an appraisal that they did. But I would say that the appraisal would be your best defense, because that's where it came from. That's our proof. That's the receipt. That's documented. Okay, you're not an expert on the size of the house, and you may have a conflicting situation, right? 2,000 square feet to 25. That's a big difference. 500 square feet. That's a huge. That can alter price, right? So where are you getting the information? Make sense? All right. Rule number 7. When something feels wrong, right? That butterfly in your tummy, something just doesn't feel right. Call your broker before it becomes a lawsuit. Yes. Okay. I run multiple offices as the managing broker. One, this is my baby, South Bay. So this is where I spend the majority of my time. But I also the broker for the Long Beach office and the Valley office as well. You know, and what's so ironic and funny is that because I've been in this industry for a very long time, I get calls from people that are not even with me asking for advice. Yeah, it's funny, but it's true. While my broker is not calling me, and I thought I would call you, Simon, because you always pick up your phone. Okay. You think I'm going to give advice to someone that's not licensed under me? Absolutely not. Why? I'm not your broker, first and foremost. I don't know your policies and procedures. I'm not going to say something that's going to jeopardize you or me, right? I shouldn't be giving advice to someone that's not licensed under a brokerage. I politely, respectfully, and professionally just says, unfortunately, you need to speak with your broker. Um, and I have a lot of great relationships with a lot of people, but I just don't give real estate advice.
No different than when a family or friend member then contracts with another real estate agent that they now have an issue.
That's right.
Now they call you for the advice. You have to get the same advice. I cannot advise you because you're now someone else's real estate.
That's right. Yeah, 100%. But I'll go out to lunch on your tab. We could talk about other fun stuff. But yes, call your broker before it becomes a lawsuit. Written unusual contract language, advising on legal rights, major non-disclosure issues, threatened litigations, responding to a demand letter, unusual deposit recommendations, difficult cancellations, dispute regarding your earnest money deposit, suspect fraud, a suspicious fraud, undisclosed material conditions, something you never encountered before. So these are just some of the surface questions that you should be, maybe I need to bring the broker in, right? I'd rather get your call before the problem than receive a lawsuit. I'd rather have a conversation, spend a few minutes answering and guiding you than getting slapped with the lawsuit. Because guess what? When the company gets sued, Simon's name is all over. You know how many times I've been sued? And I'm not even in the real estate transaction. I'll be darned. What did I get myself into? Well, it's because I'm appointed as the broker, the corporate officer for the corporation or the broker of record. So I knew what I was getting myself into. And I love it. I love the challenge. Do I have my days? Yeah, I'm a human being. But I enjoy helping our agents with tough situations. You know, that's what I do. I'm a servant. And I think that goes to my law enforcement background too, supporting or helping the community. Any questions regarding this slide? Y'all understand?
Simon,
Okay.
I have a question.
Okay.
Um, Initially, my sellers had complications in evicting the current tenant, and now they're talking about because of the demand of wanting a vacant duplex, they're wanting to consider and move forward on eviction. Is that something that I could disclose to potential buyers?
Disclose what? That
The fact
your client.
the fact that the seller is moving forward on evicting the tenant.
Okay, let me ask you, what do you think? Is that considered material fact?
I it's really touchy for me because when a buyer asks me, I know in the back of my mind that they've been attempting to do so. However, I don't
Whoa,
want
whoa,
to
whoa,
make
whoa,
any.
whoa, whoa, whoa. Wait. So attempting one thing than actual doing it.
Yeah.
So that's going to be your position. If they're thinking about it, then no. But if they started, then yes, that's considered material fact. I
Okay.
think you answered your own question.
I think I did too. Okay. Uh, yeah, it makes me a little nervous to mention it.
Well,
So,
talk to me after.
okay, sounds
We'll
good.
jump on a call.
All right,
Yes, sir.
sounds good. Thank you.
Thank you.
One of the things she mentioned, she used the word eviction. Saying in the sentence here, when she's talking about buyers wanting the unit vacant. So understand the distinction between eviction and notice to vacate, which is a completely different scenario. A notice to vacate is a landlord giving their tenants a notice, either 30 or 60 days, depending on their tenancy, okay, for them to then move out. Not that they're behind on rent or anything, because they're on a month to month now at that point. So, versus an eviction is, I want you off, you didn't pay your rent. Okay. And so, and one's adversarial, one is just a procedure. So there's, understand the distinction.
Yeah, good point. Thank you. So what will you do? All right. So I'm going to rapid fire. Not that we're going to spend much time because I know we're a little over our time. And again, all of this is being recorded, will be syndicated through YouTube. And if you want the presentation, just let me know. Seller says, don't disclose the leak, it's repaired. I want you to just think about it, right? And then the answer is you don't conceal a known potential material fact. Number two, buyer asks, is that crack structural? Your answer should be, don't diagnose, recommend a qualified professional. That's a very good question. I don't know. I'm not an expert when it comes to that particular field, but let's get a qualified professional to look into it. Okay. Buyer wants to remove contingencies to avoid losing the property. Explain the risks, document instructions to let the buyer make that decision. Well, Simon, do you think I should release my last loan contingencies? What should your answer be? I'm asking.
Should I, you're asking me, seller.
Yeah, I'm the buyer. I'm the buyer, and I'm asking you as the agent, should I release my contingency? Okay.
Yeah, or an escrow.
Okay.
Escrow.
Well, no, not.
I'm just hearing you guys. I just want to know where your head is at.
Should I release my contingencies? Have all, I think something should have been met before you release the contingency, whatever that would be.
Here's the simple answer. Okay. The simple answer is, remember, are you buying as an agent? Are you buying the property?
No.
Okay. Are you making the mortgage payment? Are you going to handle the insurance?
No.
Are you going to do any improvements? Okay. So the answer should be reflected back to your clients. This is going to be your decision,
Because we knew something.
Oh, yeah. I'm asking you, if the buyer is asking you, should I release that contingency? Your answer should be, it's really up to you. Based on what we have, the facts, right? Today is the day that we should be releasing loan, but talk to your lender and ask the lender where we're at in the position. Remember, there's always a risk. And if you release that and don't get the loan, or you decide to not purchase it, your deposit may be in jeopardy. Know the risk involved. But I'm not going to put myself in that position. You have to tell me. I'll prepare the extension if I need to, or the release of that contingency. Okay. So if you know how to maneuver this, it's an easy conversation to give to your buyers. Listing agent verbally promised me a 10,000 credit. Okay. What's the key word? Verbal. Okay. Verbal. Nothing. What did I say earlier? Nothing should be. Everything should be in writing. Yes. Get the property documented in writing. Seller says that the addition is permitted. Okay. Verify the source before advertising it, right? Mr. Mrs. Sellers, thank you. You have the permits, right? Where is that? Oh, yeah, yeah. If you go to the city, here's the information that I got or from the contractor. Verification, wherever you have it, that's going to be your proof. Yes.
When something, why would someone not with this record document? Does your taxes go up? To expert with the bureau?
Yes.
Yeah. Yeah. Any change in the property adding will definitely may assess, and I say may because I'm not an expert, may assess your taxes. I'm not going to say yes, it's going to automatically, right? But it also depends, how you did the addition, right? If you did it yourself and not told anyone, well, then the assessors are not going to know, right? But if you got a licensed contractor, it's still your job as a seller, as a homeowner, because that can also impact you in the future when you're ready to sell, right? You rather show the additional square footage because now you can compare apples to another property that's selling for 100,000 more because it's 3,500 instead of 3,000 square feet. Does that make sense? So that's where you need to ask the contractor, what you may call it, ask the contractor. I already lost my chain of thought. As the contractor, are they going to submit the paperwork or do I need to do? In most cases, the consumer or the homeowner needs to submit it to the assessors that you added additional square footage or an extra bedroom or of that nature. Buyer refused future inspections. Document that the recommendation was made, right? Again, can you force the buyer? You need to do an inspection. Okay. Otherwise, we're not going to be able to move forward. No, if the buyer doesn't want to do any inspections, I get it. You cannot force them, but you want to document it that this is what they told you. They don't want to do it. And there's a document to waive those inspections. Okay. Be clear and concise. I just got 3 more slides, guys, and we're done. The 6 D's. Okay. Take a photo of this if you want. Number 1, disclose. Number 2, document. Number 3, don't diagnose. Okay. Number 4, don't promise. Number 5, deadlines. And number 6, discuss with your broker. The 6 Ds. If it's potentially material, don't bury it. Important conversations and instructions belong in the file. Stay within your professional competence. Explain process and rights don't guarantee outcomes. Know the contract and manage the timelines. And escalate unusual situations early, right? Because that's ultimately your position. Make sense? Discipline over fear. Don't teach agents to fear lawsuits, right? And I said this throughout the presentation. I'm not here to put any fear, okay? But I want you to be mindful and understand and cautious. If it feels that it's going somewhere where you don't want to go, okay, then that's telling you maybe you need to discuss it with us. Teach them to be disciplined. Again, this is kind of a reminder for myself too, as well. Fear creates agents who avoid this difficult conversation, right? Because I'm not here to put any elements of fear because that's not what the whole content of today's presentation is. To be mindful and understand, right? And it's no difference than, growing up, right? If your parents would say, hey, don't touch that because it's going to burn you. And then you go and touch the stove or you go touch the pilot and you get burned. You're not going to do that again, or you'll know that that thing is going to burn you, right? So you won't do it. So this is what today's lessons is. I just want you to be mindful is if something just doesn't feel right, bring your support team into the picture. If it's your mentor, if it's your productivity coach, it's your broker, whoever you feel that is part of this position is the individuals that you need to bring. Make sense? Discipline creates agents who disclose communication documents, stay in the lane, and use the proper forms, right? I want all of you and the people on Zoom to understand is we run a very tight ship here, and it's all about educational base, right? We want to make sure you're armed with the right tools, and we're better than that, right? Because there's a lot of real estate brokerages, not naming anyone, but there's just they don't have the same level of training and support, and I'll leave it at that because I know I deal with them all the time. All right, and this is my final presentation, and again, thank you for sticking around. But the best lawsuit is the one we win. It's not the one that never gets filed because we handled the transaction correctly from day one. Okay. So, if we ever in a lawsuit, right, and you may be in your career, I'm not going to stand up here and say, hey, you do everything right, and you're never going to be in a lawsuit. You can do everything correct, and you may still be in a lawsuit. That's just fact. But know that you at least have the knowledge and understanding and documentation in place that if we have to go to court, I will back you up and we'll go together and we'll defend the case. Obviously, if we need to get an attorney, the attorney will be there as well. But knowing that in the reinsurance that you did everything in your power to do the right thing. And with that concludes our class. Thanks, everyone.
Thanks, Simon.
Thank you,
Thank you.
Simon.
Thank you. Thank you,
Thank you.
everyone. All right, I'll see you on the next contract class. And a reminder for everyone, next Wednesday, we have our team meeting. We're going to be talking about Mega Camp. A lot of us went to San Antonio, Texas. Got a lot of great stuff that we're going to have a panelist here at the office. Love for all of your support to be here, if it's on Zoom or in person. All right.
Thank you, Simon. I'll call you in about an hour.
Okay.
Okay, thank you.
Even the property, we have an HOA